Hi there, this is Anne Smith. Welcome to my channel on family law and mediation and related topics. Today I want to talk about guardianship in terms of Section 24 of the Children's Act. So, guardianship will come into play in two situations, or actually three situations. So, one will be if the parents decide that there is a need for another guardian, then they will consent to it. Another situation will be where the child doesn't have any guardians or the parents are not around and that appointment is required. Or if the parents are deceased and they actually stipulate in their will that a specific guardian has to be appointed. So, in terms of the Act, any person having an interest in the care, well being, and development of the child may apply for guardianship, and the order will be granted by the court. So, the court will look at the best interest of the child, the relationship between the applicant and the child, and any other factor that the court might take into consideration. So, if somebody applies to become a guardian of the child, they must also give reasons to the court as why the current guardian is not suitable to look after the child. Or if there's just an additional guardian needed, then they will just stipulate the reasons for that. In a situation where a child has been, the parents are deceased and the guardian is appointed, the person obviously has to accept the appointment for it to come into effect. So, Section 29 um, of the Children's Act explains the proceedings, and stipulates what needs to be contained in the application. So, a guardian must give reasons for not wanting to adopt the child. The court can grant either conditional guardianship or unconditional guardianship, or dismiss the application if it finds that it's not in the interest of the child. A report must be done by a social worker or the family advocate, which will also be attached to the application. So the court can order that further investigations have to be conducted, or that a specific matter be investigated relating to the child. The court can also order that somebody appears in court and actually gives evidence surrounding the circumstances. If by any chance somebody opposes the application, they have to bear the cost of any further reports or experts that need to be appointed in order to justify them opposing the application. The court can also, in extreme circumstances, appoint a legal representative to represent the child if it so needs. And if the court finds that the child is in need of care, the child can be put in a place of safety and the case can be referred to a social worker for further investigation. Then, lastly, what is very important is that Section 31 of the Children's Act makes provisions for the child to be heard. So, in your application, it's very important that the social worker also has an interview with the child to make sure that the child's views were taken into consideration, that the child is happy to be with that person that has been appointed as a guardian. The Act makes provision for the children's rights, but it's also important for the child to have a say. That way, avoiding them being unhappy and then making the family situation unbearable for the guardian. Why is a guardian necessary? Guardian will basically have the parental rights and responsibilities that a parent would have had. So the guardian can make decisions regarding a child obtaining property or enrolling in university or school, and also if there are any medical procedures that the child needs to undergo. It's important for the child to have a guardian to consent to those kinds of procedures. I hope this was helpful and you enjoyed it. If you have any other questions, you're welcome to send me a message on my Facebook page. You can also comment on the comments below, and kindly like, subscribe, and share. Until next time.